Hi folks, and welcome back to Conveyancing. This is video 2 in the video series on remedies. And in the first video we had a look at what remedies might be available depending on what had happened, and we looked at the issue of election, and then we looked at the issue of termination. And now we need to look at the issue of damages. And as you recall from your contract law days, all breaches of a contract will entitle the aggrieved party to claim damages. The aim of damages in contract, according to the very, very old case of Robinson and Harmon, to put the party into the position as if the contract had been performed. As if the contract had been performed. So you're trying to give the parties what they expected to get if everything went okay, and that's why they're sometimes called expectation damages. If you are relying on the contractual right to terminate, then you need to have breach of an essential term or repudiation before those full expectational loss of bargain damages are payable. If you haven't actually lost the whole of your bargain, then you're not going to be able to get loss of bargain damages. You'll be restricted to the other kinds of loss that you've suffered, perhaps some kind of consequential or other loss that has flowed from the breach that has occurred. Looking first at damages of common law, this slide really just reiterates what I said to you in the last slide. You can revisit it again at your leisure if you wish. It just basically says the same stuff. But in terms of valuing the loss, generally speaking, for the seller, you're going to be looking at the difference between the contract price and the market value as at the date of breach, as well as any other consequential losses that might have been suffered. Particularly where the seller is terminating, they're going to be looking at forfeiting the deposit, and that will get deducted from the overall assessment of damages that the party in breach will owe to the seller. Obviously, where you're looking at calculating damages, you need to bear in mind those old issues of causation, remoteness and mitigation that we covered in our contract law unit, and the text deals with those quite sufficiently, so there's no real need for me to traverse all of that again. But more specifically, I just wanted to make sure that you're all okay with calculating the loss in terms of damages, so how it all plays out in applying the principles. And the Liverpool Holdings and Gordon Linton car sales is a nice simple little example for us here. The gross contract price there was $285,000 to buy the property. The buyer refused to complete. Okay, so very clear breach there. As at the date of breach, the value of the property was $145,000. So the damages are the contract price of $285 minus the value as at the date of breach, $145. So the damages payable were $140,000 minus the deposit that had already been forfeited. Okay, fairly simple, not really rocket science there. It will be brought into further relief, I think, when we talk a little bit more about calculating the amounts receivable if you're going to claim under the REIQ contract for deficiency on sale. So just bear that in mind, a little bookmark there for a future discussion. What about consequential losses? Now, there are lots and lots and lots of different losses that might flow from a breach, and some of them are settled as being perfectly fine and acceptable to claim. Some of them are not. Generally speaking, you won't include costs of the aborted sale as part of your damages claim, because your client will have already had to meet those costs if the sale had gone through. So you can't really, and that's what it's all about, isn't it? Putting your client in the position as if the contract had been performed. What you can include is costs of the new attempt to sell, so the resale after your first contract has gone through. You've had to sell the property fresh on the market, and you can include those costs, so legal expenses, your agent's commission, and other settlement expenses. So that's relatively clear, but other types of consequential loss are really not so clear. Costs of repossession, if you've got to boot the other person out of the house and change all the locks and so forth, generally speaking, yes. Holding costs like rates, water, land tax, body corporate, tends to be yes in Queensland, no elsewhere. Interest on your mortgage payments, you generally can't claim those. So, and the text goes into further examples there, but that's sufficient to give you the idea. Certainly you can try and claim the cost of the resale, but apart from that, there's a little bit of mixed response in what else you can actually claim for in terms of consequential losses. Now, deficiency on resale. This is where I said things will be thrown into a little bit more relief for you. So you can see I've given you some snippets out of Clause 9 of the standard REIQ Houses and Land Contract. Clause 9 deals with the parties' default. We know that they have the right to affirm or terminate where there's a breach of an essential term or fundamental breach of an intermediate term. Okay, that's fairly basic. Skip over to 9.4. If the seller terminates under 9.1, it can do all or any of the following: resume possession of the property, forfeit the deposit and any interest earned, sue the buyer for damages, and resell the property. So the two that we're contrasting here is suing the buyer for damages and reselling the property. Now, the main difference between a damages claim and a contractual claim for deficiency on resale is, as I've got down there at the very bottom, risk. Risk is the main issue that you need to bear in mind for your client. And it all kind of has to do with whether the market is, rising or falling, whether the house prices are increasing, the comparable values of properties in the area and comparable sales are increasing, or whether they're decreasing. Okay, so, and that then links into the date at which the loss is crystallised. So in a damages claim, it's going to be crystallised as at the date of breach. And for deficiency on resale, it's obviously going to be as at the date of resale. Okay, looking over at clause 9.6, seller's resale, if the seller terminates the contract and resells the property, the seller can recover from the buyer as liquidated damages any deficiency in price on a resale and expenses connected therewith. So that'd be your consequential losses, provided that the resale settles within 2 years of termination of this contract. Okay, any profit on a resale belongs to the sellers, and obviously if you're making a profit on the resale, then you're not going to be able to claim any substantial damages from the buyer that was in breach in the first place, are you? The Amger and Mitchie case, I think, should flesh things out for us and make it all abundantly clear. Very unfortunate case indeed. We had the sale and purchase contract being for a purchase price of $160,000. We had the buyer then repudiating the contract, the seller accepting the repudiation and terminating. Now, as at the date of the repudiation, so date of breach, it was established by evidence that the property was worth $173,500. So as at that point, the seller actually hadn't made a loss, had they? In fact, they would have made $13,500 profit. However, the seller then put the house back on the market, tried to sell, unfortunately sold for $80,000. So significant loss, half the original price. Now, there was a clause 11 in that contract that dealt with the seller's remedies for breach. And it allowed the seller to claim deficiency on resale. So when the litigation was brought, the seller kind of assumed that they would have been able to enforce clause 11 against the buyer and claim the $80,000 difference between the contract price and the deficiency on resale, or the resale value. Unfortunately, it was held in that case that because the seller had accepted the buyer's repudiation and terminated the entire contract and they could no longer rely on the ability to claim a deficiency on resale that was expressed in the contract. It was only if the seller had actually followed that clause 11 to a T and had repossessed the property as the clause required, and to then resell and then claim the deficiency on resale, that they would have been able to claim that $80,000. So very unfortunate there. You need to look very, very carefully as at the contract and whether the market is rising or falling. So the upshot of all of that is don't make the sub-election between damages and deficiency on resale until you know whether the market's rising or falling. Have a little look at the text on this. LCQ discusses how you can reserve your rights and other factors to consider there. At the end of the day, if the market's falling, it's better to obtain damages as a deficiency in the price on resale, because when you're claiming deficiency on resale, it's going to be at the buyer's risk. As long as you think that you'll be able to sell the property within that 2-year period, if you've got an REIQ contract, then you should be home and hosed and you won't be in that unfortunate amber kind of situation. If the market's rising, then rather sensibly, it's probably better to elect to just be done with the whole thing, obtain damages which are calculated as at the date of breach, and then sell the property later and make any profit yourself as seller. So that is the issue of deficiency on sale. Now we need to look at the buyer's situation. If the buyer is terminated for the seller's breach, they can also claim loss of bargain damages. Section 68 of the Property Law Act says, particularly if the seller fails to give good title, the buyer can claim loss of bargain damages. The same measure is going to apply, so the difference between the contract price and market value as at the date of breach. What about consequential losses? If you're getting loss of bargain damages, then you're not going to be able to get damages, as I said down there, for legal expenses and stamp duty, that kind of thing, as you would have had to incur those anyway as a buyer. If you're not getting loss of bargain damages, then there's conflicting authority about exactly what you can claim, a little bit like we discussed with the seller, so I'll leave you to explore that in the text at your leisure. What about the afters? What about after affirmation and after completion? Well, after affirmation, a buyer can certainly seek compensation either under the contract or at common law for things like failure to give vacant possession, breach of your promissory warranties, adjustment of payment of the adjustment of outgoings and that kind of thing. What about after completion? It gets a little bit more complex because the doctrine of merger comes into play. At common law, you can't claim for defects in title after completion, but have a look at REIQ 7.5. You certainly can claim for errors in the boundary or area of the property, encroachments or mistake or omission in describing the property or the seller's title to it, but you will remember that you need to claim those damages prior to settlement in order to get them after settlement. Okay, so you've got to get in early there. So that is the buyer's situation, and that is the position of common law. Now, under the REIQ contract, we have clause 2.4 sub 3 that says if the contract's terminated, the buyer has no further claim once it receives the deposit and interest unless the termination is due to the seller's default or breach of warranty. Okay, so looking first at breach of warranty, these should all be reassuringly familiar to you. The seller warrants that the land's going to be freehold. If it's leasehold, it's going to be the lessee and so on. It warrants that the seller has capacity to complete. There's going to be no unsatisfied judgments. There's nothing suspicious in relation to the environmental protection legislation and so forth. We've certainly covered these in a previous video series. But have a look at 7.4 sub 5. We did mention this previously, but I'll reiterate it again for you. the seller doesn't warrant that the present use is lawful. So whilst you might be able to claim damages for any of those specific warranties in 7.4 sub 1 and sub 2, sub 3, the seller specifically does not warrant that the present use is lawful. So you cannot claim damages if it turns out that the present use of the property is in fact unlawful. Okay, and that is where your searches become just so important. So that's seller's warranties. So what's the situation in relation to default? Well, you find the ability to claim damages under clause 9. The seller's ability to claim damages are pretty much the same as the buyer's ability to claim damages, except for the seller can also claim damages for cost of any works or expenditure required under clause 7.63, and that is the provision that if you'll recall back to a previous video series where an authority has required various works to be done pre-settlement, and the seller has to undertake those, they can claim the cost of those works back from the buyer. So that is the situation in relation to the REIQ contract, and that's damages. Looking more specifically at specific performance, there's no real need to labour this issue. I think we're all, or we should be, across the remedy of specific performance by now. If not, please go and refresh your memory in your contract law notes. It compels settlement of a contract. It's done by way of order of the court. The plaintiff themselves has to be ready, willing and able to complete. If there is a seller that wants to obtain an order for specific performance, they also have to be ready, willing and able to complete. If there's a defect in title, they may still be considered ready, willing and able to complete if that defect is only minor. So please don't consider that any defect in a seller's title will disable them from seeking an order for specific performance. They may still be ready, willing and able if the defect is only minor. We know that because specific performance is an equitable remedy, there are going to be other limiting factors around this, laches, hardship, illegality, all of those major ones, as well as if there has been any naughtiness by way of misleading or deceptive conduct. So that's specific performance, just a very, very brief cook's tour of it there for you. Like I said, if you're feeling like you need to know a bit more of the ins and outs, please go and read the text and or your contract law notes. Okay, so we've passed the wonderful break mark again, so I'll leave it there for this video. I'll come back again for the third and final video in this video series, and until then, bye for now guys.